So as we wait for everyone, morning to the panelists. Welcome to this discussion today. And to those that have already joined us, welcome to this very critical issue we are discussing today. As you will all notice, the theme for our discussion today is trends in domestic litigation on the constitutionality of COVID-19 and lockdown regulations in Africa. Before I break down the theme for today, I'd like to bring it to our attention that we'll be having perspectives from a number of countries. We'll have perspectives from Kenya, we'll have perspectives from the Central African Republic, we'll have perspectives from Malawi and South Africa. But you know, as pondering through this topic, I looked back at March, 2020, when the lockdown in South Africa was actually first declared. And you know, in that moment, there was so much vulnerability. If I remember, when the regulations came, we were so desperate because we didn't know what the pandemic was about. We had no clue. We didn't know what was going on, how it spread. And people were so, committed to, honoring the regulations, abiding by them, and so on and so forth. And I want to believe that not many of us actually saw litigation being part of the package, honestly. And no one ever saw the court being involved. I remember around that time, Justice Muhindo, when they were actually, the Chief Justice, when he was actually discussing about how the court would actually function during the COVID-19 pandemic, he actually noted that the court will not be functioning as usual because there seemed to be a general assumption that the court will not be active because of the pandemic. But it later turns out that during this pandemic, actually, the court has been active more than many of us anticipated. And I'm looking back at this point in time, and I'm looking at the various forms of litigation that are taking place across the African continent. And I'm forced to wonder what really happened between March, when people were so desperate to honor the regulations, when people were so scared, of the pandemic. And now we are at a point where people are really frustrated, so much so that they're not just stopping at the frustration, they're going as far as challenging the regulations that we thought were actually out to protect, the population. So the discussion today is basically going to engage with what really happened, what's going on, what's happening in the courts in Malawi, what's happening in the courts in Kenya, what's happening in the court in the Central African Republic, what's happening in the court in South Africa, what changed between March, and now. I know in Malawi, we have court, litigation going on as early as April. Did things change sooner there? Why did it take long for litigation to start in other countries? Who is litigating? What are they litigating about? Why are people dissatisfied? What are the courts saying? So we're going to be engaging with all these issues, and I'm really, really excited. I'm looking forward to the engagement from the various, panelists that we have here today. But before we proceed further, you will notice by now that there is a poll that has popped up. Please engage with it. Answer to the questions that are presented to you, and we will proceed further. For now, I'm going to ask very incredible panelists to actually introduce themselves. How the presentation is going to work, they will introduce themselves. Having introduced themselves, each one will actually give us a presentation of the perspectives from the different countries they will be talking about. And after that, we'll follow it up with questions. So I'm going to start with Mr. Muhindo.
Thank you. My name is Trésor Makunya Muhindo. I'm an academic associate and doctoral candidate at the Center for Human Rights, Faculty of Law, University of Pretoria.
Thank you. Welcome, Mr. Muhindo. We look forward to a fruitful discussion with you.
Thank you so much.
Mr. Dr. Biegon.
Good morning, everyone. My name is Japhet Biegon. Work with Amnesty International, but also associated with the Center for Human Rights as an adjunct lecturer.
Welcome, Dr. Biegon. Looking forward to a fruitful discussion with you with regards to the Kenyan cases. Dr. Chiramba, are you there?
I am Okyerebea. I hope I'm clear that side.
Yes,
all right. Okay, so I'm the deputy head of department in the foundation law department at the University of Malawi in the Faculty of Law, and I'm the lecturer in international human rights law and also in public international law. And I'll be presenting perspectives from Malawi, what the courts have said in relation to regulations aimed at responding to COVID-19 and also the lockdown that was eventually enforced by government. And I look forward to this engagement. Thank you.
We look forward to engaging with you, Dr. Shilapa. Welcome. And then finally, but last but not least, is Ms. Ampofo-Anti. Please speak to us. Are you there?
I am. Good morning, everybody.
Good morning.
My name is Okyerebea Ampofo-Anti. I'm an attorney based in Johannesburg, South Africa. I'm an alumni of the program, as I believe everyone else here is. And I run a consulting practice focusing on media law, data protection, and the intersection between technology and human rights in Johannesburg.
Welcome. We look forward to a fruitful discussion with you. So our panelists have introduced themselves, and as you can gather, they have a wealth of experience, and they do not just have the experience, but they have worked in these respective countries. So we definitely are looking forward to their presentation. They have between 3 and 12 minutes to present. During that time, they are going to actually raise questions in the chat room, which we will actually attend to. But as they present, then allow them to actually.
Sorry, Emma, we are having problem with your sound.
Yeah.
Can you hear me?
It's very bad.
There is an echo. It was good at the start, but I don't know what changed.
I wonder what changed. Is it better now?
Nope.
No. I don't know what else to do.
May I suggest we move to the first presentation and then we can try and fix the audio?
Hello, can you hear me now?
No, still with the echoes, so it's not clear yet.
Okay, for now, let's proceed with the presentation. Incidentally, I would have loved to hear the presentation so that we get the presentation further. I don't know what else to do, but I might have to log in using my phone. Possibly that would be much clearer. I don't know. Because for now, I'm using a laptop. I'm trying to see whether I can leave and be allowed out in the meeting again.
But perhaps we can just continue with the first speaker in the meantime. I suggest. Thanks.
Trésor, are you ready to present?
Yes, sure. Thank you, Serena. Thank you, Prof. Thank you, Emma, for the opportunity. As I said, my name is Trésor. I'll be speaking about the role of constitutional courts in upholding constitutionalism and democracy in emergency situation in French-speaking African countries. And I selected the Democratic Republic of Congo Constitutional Courts and the Central African Republic Constitutional Courts. So in the next 10 to 12 minutes, I'll be talking about the theoretical foundation. Why did I choose these two countries? Then I will look at the context in the two countries. I will also look at the framework and then complete with some implications on constitutionalism and democracy. From the start, I would like to point out that the Constitutional Court of the Democratic Republic of Congo and the Constitutional Courts of the Central African Republic have a similar nature, which means these are courts which are supposed to be outside the hierarchy of the judiciary, and they operate what we call the centralized constitutional review, unlike common law African countries where you have a decentralized review of constitutionality, meaning that the high courts and other courts can also review the constitutionality of legislations and the regulations. In French-speaking countries, you have one court which does this, and this is the Constitutional Court. So the two courts perform the same role, and generally the review is before an act of parliament is enacted. So although I'll be discussing about different subject matters that came before the two courts, I assume that the courts, the two petitions were submitted by the majority in power and the majority in parliament, and they were linked with COVID-19. So they will give us a certain perspective on how a democratic deficit can be filled during a pandemic. So let's go to the context. The first context in Democratic Republic of Congo in March 2020, they have discovered the first coronavirus cases, and then later the President of the Republic declared the state of emergency. So the declaration of state of emergency, which was followed by a number of measures adopted to curb, to flatten the curve of the coronavirus. So the question which I will be responding to is, did the declaration respect the procedure provided for under the Constitution, and were the measures actually consistent with the Constitution and the Bill of Rights? So in Central African Republic, you have a different context, a context where presidential elections are supposed to be organized in December this year in 2020, and parliamentary elections are supposed to be organized in March next year. So 2/3 of members of parliament from the ruling coalition drafted a constitutional amendment act, providing that because of COVID-19, there will be difficulties to organize elections in December. So the constitution should be amended in order to provide, to extend the term of the president in power and to extend also the term of the National Assembly. This is the case which went to the Constitutional Court of the Central African Republic. The question I will be responding in that regard is, can actually COVID-19 justify the extension of presidential term and parliamentary term, and how compatible these were with the Constitution? So in terms of the legal or the constitutional framework, we have in DRC, for example, the president is allowed to declare the state of emergency when the survival of the nation is endangered. So when exceptional circumstances stops the proper functioning of institutions, but also they are obligated to consult with the President of the National Assembly, the Senate, and the Prime Minister. Although this was done, the crux of the matter in Democratic Republic of Congo was twofold. The first one is, should the president receive authorization from Congress? And Congress, I mean the National Assembly and the Senate together. And secondly, what type of legal act declares the state of emergency, and how can it be controlled by the Constitutional Court? So the issue which went to the Constitutional Court actually was first to review the constitutionality of the declaration. And in general theory of constitutional law in French-speaking countries, you have two types of acts, what's generally called the actes du gouvernement, which are the decisions which have been adopted by the cabinet during Council of Ministers, and this can be reviewed by the Constitutional Court. And you have the acte du gouvernement, des gouvernements, which is a sovereign act that is adopted by the President of the Republic, and according to theorists, this cannot be reviewed by the Constitutional Court. So they went before the Constitutional Court, and the first problem is, while the declaration of the state of emergency and the measures adopting the state of emergency have to be adopted in two separate acts, so the acte du gouvernement and the acte de gouvernement, they were merged in one document. And that was the first problem the court had to resolve. Unfortunately, the court did not look at this issue and argued that the president were not obliged to consult with the Congress because bearing on the situation, the COVID-19, there were difficulty to put together 600 members of parliament. The second issue is about human rights. The measures which were adopted violated, restricted, I can say, certain fundamental rights. I can look at the freedom of movement, the right to assembly, and certain rights related to religious rights, like, for example, the prohibition of religious gatherings. So the court did not delve into human rights issues which were raised by the declaration of the state of emergency. And this, I found it very problematic, because the court should have laid at least some theoretical foundation to guide the government in future declaration of emergency. For example, to what extent human rights can be restricted, what are the acceptable restrictions, and how far cannot the government go. So those are some issues that were not dealt with the Constitutional Court, and I will come back to that when I'll be dealing with the implications. So in the Central African Republic, you have a different situation where now the Constitutional Amendment Act goes to the Constitutional Court, because, as I said, the nature of the review which is performed in French-speaking countries is like in most French-speaking countries in Africa, is a pre-enactment constitutional review, which means before a bill is assessed by the President of the Republic, the Constitutional Court has to confirm whether it complies with the Constitution or not. So the Constitutional Amendment Act went to the Constitutional Court, and the Constitutional Court ruled that the Constitutional Amendment Act violated the Constitution because it extended the term of the president beyond what is accepted by the Constitution. And it also argues, contrary to some other African countries, which allows the president to remain in power when elections are not organized, the Constitution of Central African Republic did not allow the president to remain in power, nor the members of parliament to remain there. So elections were to be organized. However, the Constitutional Court did not clearly indicate whether COVID-19 can be used as a ground to postpone elections. So one of the arguments which were raised by members of parliament in proposing the amendment to the Constitution was like the COVID-19 constitutes what they call the force majeure, which is this exceptional circumstance which liberates someone from implementing the constitutional obligation. But the court did not deal with that issue. But the court also was interesting. The reasoning of the court was interesting because the court argued that although one can agree that some circumstances which were not provided by the Constitution can extend the term of the president or the parliament, but this has to be done in consensus. So you have to consult all the political forces existing, the opposition and the ruling coalition, but also you have to consult with the civil society and other groups. So this is the obligation which was imposed by the constitutional courts. But one of the questions is the consultation has to be conducted by the ruling coalition, which means the executive. The Constitutional Court did not also indicate when should this consultation be conducted and what is the notion even of the force majeure. Then now the big question is, will elections be organized in December 2020, or the government will just keep quiet because the court did not impose a period within which those consultations should be organized. So one would expect that the executive will do it. But if the COVID-19 continued to spread, I checked this morning in Central African Republic, they have actually 4,700 cases. And let's hope that it will go down. And if it doesn't go down, there will be certain problems. So what is the implication of these two cases, not only on constitutionalism, but also on democracy in Africa? I view the two decisions as trying to address democratic deficit. So democratic deficit in Central African Republic was properly addressed by the Constitutional Court when the Constitutional Court actually required the executive to consult all the parties represented in parliament, but also the civil society, the broader constituency, because the court argued, for example, the nature of the 2016 Central African Republic Constitution was such as it required a large consensus because the country is a post-conflict country, and an amendment to the constitution can put back the country where it was in the last 10, 20 years. But in the case of Democratic Republic of Congo, you see there was no emphasis on democratic participation, apart from the institution that the president were required to consult with, which means the prime minister, the president of the National Assembly and the Senate. There are no large consultation in terms of the people who will be affected by those measures. So my conclusion is that the COVID-19 also exposed to the extent to which we have a kind of democratic deficit in constitutional decision-making in terms of at the executive level. The second implication, in my view, relates to the transparency in the reasoning of the two constitutional courts. Transparency and argumentation helps actually to educate the people, to educate participants in a constitutional adjudication. When the court's reasoning is articulated, when the court's reasoning is clear and sound, individuals know already the extent to which the extent of the obligations, but also in the future, what type of argument they can invoke and what type of argument they can't invoke. But when you look at these cases, there are many silences, there are many issues which were not addressed and which may pose problems in the future. And the last element, and I would like to stop at that level, is the level of constitutional culture. So my colleagues will be talking about other countries, but you will notice that in most French-speaking countries, there was no individual petition against emergency measures or emergency declaration. So the two petitions, for example, were brought in the case of Central African Republic. The petition was brought by the President of the National Assembly because he is required by the Constitution. In the case of Democratic Republic of Congo, you saw that the Constitution requires that the emergency measures are reviewed by the Constitutional Court. But in terms of individuals who actually are lamenting about those measures, and not far from Monday in DRC, for example, they prohibited demonstrations in order to prevent the spread of coronavirus. But you don't see the move of individuals to go to court to engage with judicial bodies in order to defend constitutionalism. So these are the three implications I identified, and what the COVID-19 actually exposed the weakness of constitutionalism mechanism in African French-speaking countries. Thank you so much.
Thank you so much for that very insightful presentation. I have a few issues that I would like to follow up on, but we will, I think, engage with them later. That was quite insightful. But going forward, we will proceed to Dr. Biegon, who will give us the perspective from Kenya. We'll reserve our questions for the end of the discussion. And like I said, please feel free to post the questions via the chat room. We will engage with them after all the four presenters have made the presentation. So thank you so much for the perspective on the Central African Republic. We're straight away going to the perspective of who is, Dr. Biegon, are you there? Dr. Biegon? Dr. Biegon, are you there? I think we lost him. Dr. Chilemba, can you hear me? Can you hear me?
Yes, I can hear you.
Okay, so I'm going to request that you proceed with your presentation. We lost Dr. Biegon. I think he'll join us after your presentation. We will, as we did before, we'll have the presentation and then we'll follow up with questions after everyone has presented. Please reserve the questions for later. You can post them here, we'll engage with them, but for now, let's allow them to present. Thank you so much. Over to you, Dr. Chilemba.
Yes, how many minutes have you allocated to me? Emma?
You have between 10 and 12 minutes.
12, not 15.
No, not 15. I'm sure you will work within 12 minutes. Thank you.
Okay, all right. Thank you very much. Okay, so I'll be giving the Malawian perspective, but I think what we should appreciate is, first of all, the context. That's so significant to appreciating whatever was going on in Malawi. We were approaching what were called fresh elections. Both the elections in 2019 were annulled for being unconstitutional, and so we are approaching these fresh elections which were held in June this year. So when the pandemic had broken out, the government was taking various measures, but there were some suspicion that this was done so that the elections should be delayed. So any measure that the government was taking was viewed with suspicion. And again, there was also some suspicion that the government was trying to abuse, government officials abuse funds that were aimed at fighting COVID-19. So I think that's the context. The other context is the Constitution of Malawi itself. It entrenches constitutionalism, and then the human rights, and then the rule of law is also so paramount. So in terms of the way the constitution is, anything that is done contrary to the constitution can be declared unconstitutional by a court. And anything again that is done which violates human rights can also be declared unconstitutional. So there are only two ways in which government can take measures. First of all, if whatever it has done, if it's impacting on rights, it must qualify as a lawful limitation of human rights. But if then the rights affected are quite a number of them, issues arise whether that amounts to derogation of rights. And for it to qualify as a proper derogation, it should comply with Section 45 of the Constitution, which only allows derogations in times of war, threat of war, civil war, or widespread natural disasters. The other thing that is also important is Section 58 of the Constitution, which talks of the validity of subsidiary legislation. So if subsidiary legislation, the one both Parliament enacts laws, which are legislation, but then it also gives power to other branches of government to enact their own regulations which have a force of law. So these are called subsidiary legislation. Now, if such subsidiary legislation affects substantially the enjoyment of rights, then it means that subsidiary legislation should be taken before Parliament. So any legislation that affects the enjoyment of rights substantially and significantly, in terms of Section 58 of the Constitution, it has to pass through Parliament, which means the executive cannot use subsidiary legislation to take measures that substantively and significantly affect the enjoyment of rights. So I think that's the context which we must appreciate. So when in the right of responding to COVID-19, the government used a number of measures. First, there were some proclamations that were issued by the president, and then regulations issued by district assemblies and city councils. And then there was also subsidiary legislation by way of regulations issued by government. So as you can see, there was no measure that was taken before Parliament. It was principally done using subsidiary legislation, other regulations, directives, and proclamations, but without using Parliament. So already you can see that Section 58 would come in the moment any person tries to challenge such measures. In fact, they affect human rights. So these things indeed happened. What was so crucial was the regulations that contained a lockdown that were proclaimed on 13th April 2020. These were made pursuant to the Public Health Act. So these were called Coronavirus Prevention, Containment and Management Rules. These ones contained lockdown. Well, the other regulations under the same emphasize the issues of social distancing and also reduction in the number of people that can gather in one place, and many other regulations that were there. But I think it was the lockdown which was a bit controversial. So as I said earlier on, almost all these measures, not almost, but all these measures were not taken before Parliament. So they were principal subsidiary legislation or directives. So what was going on was if the Malawians were okay, they would just accept them. So the government would end up enforcing them because Malawians had just accepted them. But the moment any person or group or organization challenged, then the issue would go before the court, and the court would say, but which laws are you using? Then the court would end up invalidating, or at least granting an injunction, stopping the government from implementing those measures. So there are about 3 cases. The first one was the state on the application of leaks, Xiao, and 9 others. So these were Chinese nationals that had just arrived in Malawi and then they were deported. So the government advanced a number of reasons, one of which was to do with COVID-19. But when the matter went before the court, it granted an injunction. That was on 2nd April 2019. It granted an injunction stopping the government from deporting these Chinese nationals. The crux of the matter was there was no law which the government would have relied on in deporting these individuals, because the Immigration Act did not allow for those things to happen. So the government had raised the issues of coronavirus and all that, but again, there was no law. So the injunction was in place. What the court emphasized here is that Malawi is a country that subscribes to the rule of law. So whatever the government does must be in line with the law. In this case, there wasn't anything that was in line with the law, much as whatever the government was doing made sense, but the law did not give the government a mandate to do that. So this decision was very unpopular with Malawians because at that time the coronavirus was spreading. But the court stood resolute to say anything that we do must be in line with the law. The second case was the state on the application of Steve Mponda and two others versus the president of Malawi. This one was a judicial review case. Here the president had declared Malawi a state of disaster and then had ordered the closure of all schools, learning institutions and universities. So these were university students from Chancellor College. They sought to challenge that closure, relying on the declaration of the state of disaster. So when the matter went before the High Court unpacked the matters and realized that the students were proceeding on the understanding that the president had declared a state of emergency. So the court found that what was declared was a state of disaster under the Disaster Response and Preparedness and Management Act, section there 32 and others. So the court found that the government could actually declare a state of disaster, and then it could take those measures like closing schools, because that would amount to a lawful limitation of rights. So I think it was a misapprehension that perhaps there was a state of emergency that was declared, and the court clarified that this was not a state of emergency, but a state of disaster. And since it was done pursuant to the Disaster Response, Preparedness and Management Act, it amounted to a lawful limitation of rights. Because under the Constitution and international law, you can limit rights in the interest of public health and others. So this COVID-19 pandemic was taken as a threat to public health, and so the government could limit the right to education. The matter did not go for a substantive hearing because it was a judicial review application. So the court had to assess whether it raised the tribal issues. And so the court, after sieving, it realized that no, I think even if the matter goes for full trial, it would still amount to a lawful limitation. The last case which I will discuss, which is now the main one, this one now dealt with the issue of the lockdown. This one involved Esther Cecilia Katumba and 5 others. This was the president of Malawi and also...
Dr. Chilemba, you have 1 minute.
Okay. So now this case, because the government had issued and enforced a lockdown. So when the matter went before the court said, okay, this lockdown, if you see, it is affecting so many rights. The right to economic activity, the right to freedom of movement, so many rights were actually affected by this lockdown. So when the court looked at the matter, they realized that all these rights that have been affected, perhaps the only way to do this is through derogations and not limitations. So there are so many matters that were before the court. The government had used subsidiary legislation to take measures that substantially and substantively affected enjoyment of rights. And again, it did so without declaring a state of emergency. So there were issues. Under the Malawian Constitution, can you effect a lockdown that substantively affects the enjoyment of rights using subsidiary legislation? So that's the question which the court should also do that. And again, there were so many measures that were not taken to cushion the majority, because most of the Malawians rely on hand-to-mouth, something like that. They have to go out to work, to earn, to get something to buy food. So this lockdown substantially affected all those rights. So the court saw that, no, I think in this case, there is need for a constitutional court to be impaneled so that it looks at all these constitutional matters and then make a decision. But in the meantime, the court issued an interdict or an injunction stopping the lockdown. Just to say that the new administration which has come into place now, led by President Dr. Lazarus Chakwera, has said it will not pursue the issue of the lockdown. So I think we can say the court successfully saved Malawi from the lockdown, but the issue was because it's doubtful that a lockdown under the Malawian Constitution could be declared, could be constitutional because of the fundamental effects it has on the enjoyment of rights. And again, because it was done pursuant to subsidiary legislation, when Section 58 says so. So in conclusion, we can say that it is the Malawian context which should be understood. First, rule of law. The government cannot just do anything when the law does not allow that. Secondly, is the constitutional supremacy, that whatever is done must be in line with the Constitution. And lastly, is the entrenchment of human rights under the Malawian Constitution. Whatever the government can do, for example, the lockdown could say it was important to curb the spread of the COVID-19. But unfortunately, because the lockdown substantively and substantially affected the enjoyment of rights, it had to be done properly. Parliament had to be involved, and then all measures to cushion the poor, all those that would be substantively affected had to be there. So Malawi could not just declare a lockdown like it was happening in other countries. So I think it was the unique nature of the Malawian constitution that did this. And so the jurisprudence that has developed until now also emphasizes this. Very, very lastly, to show that Malawi is a rule of law, there were a number of cases that were issued by the courts. So for example, if nightclubs and places of entertainment were closed, the moment the pub owners or entertainment joint owners went to court to complain, the court would issue an injunction. So, okay, whatever government is doing is right, but which law are you relying on? So at the moment, we don't have a law that can allow government to take all these measures. So because of that, then the courts can always come. So in conclusion, the jurisprudence that has developed, if we should sum it in one line, is this. Whatever measures the government can take to respond to COVID-19 must first of all be in line with the Constitution. If such measures are not in line with the Constitution, the courts will not be reluctant, but to declare them invalid and unconstitutional. Thank you very much for your time, and I look forward to the questions from participants.
Thank you so much, Dr. Chilemba. What an discussion. I'm sure we'll have a lot of follow-up questions in terms of who see this code. We will engage with all that later, and I think it's a very unique perspective compared to the other cases that I have read with regards to Kenya and South Africa. So it will be quite an interesting comparative dimension after we engage with you. So we straight away going to get the perspective of Kenya from Dr. Biegon, who we had lost earlier. Dr. Biegon, are you there?
I'm here this time round.
Thank you so much. I looked at the two cases that you have sent, and I'm excited to actually hear from you and what you have to say, about them. So please take over.
Thank you, Emma. So I'm going to speak about two cases that have challenged the constitutionality of the curfew that was declared in Kenya on 26th of March. And that's the first case. And then a second case that deals with the question of the right to dignity, right to religion and culture in the context of COVID-19. But before I go into the cases, perhaps I should just draw a brief picture on the context in which these cases were filed. The first case of COVID-19 was reported in Kenya on 13th of March, Friday, 13th of March of this year. As in many other parts of the continent and the world, there was fear that spread like wildfire across the country. And 13 days later, on 26th of March, the government took a measure that has been taken in the continent and in other parts of the world, and that was to declare a curfew that would last within the hours of 7 p.m. In the evening to 5 a.m. in the morning. That curfew was contained in a legal notice promulgated under the Public Order Act of 1956. And on the 26th, when that declaration was made, it would have the order was supposed to take effect from the 27th of April. Now, on 27th of April, the government unleashed the police upon the population. We had excited, overzealous, trigger-happy police officers who were unleashed upon the population on the evening of 27th to start monitoring and enforcing the curfew. In certain parts of the country, by 5 p.m., police officers, security officers were already beating up people brutally, asking them to proceed home. The result is that there was chaos and many people were brutalized, were terrorized by the police. A 13-year-old boy, Yasin Moyo, was killed by a stray bullet by the police. And in the days that followed, the whole country was really horrified by the actions of police officers. This led to the first case filed by the Law Society of Kenya, challenging the constitutionality of the curfew order as was issued by the government.
This case challenged that the constitutionality of that curfew order, and the arguments were primarily that first, the Public Order Act, being an act that deals with crime, specifically with crime, was not the appropriate act for dealing with a pandemic such as COVID-19. And the petitioner, the Law Society, argued that the proper act for dealing with this pandemic was the Public Health Act, and that in any event, the proper procedure for dealing with this pandemic was to declare a state of emergency, which comes with constitutional safeguards for human rights, but also parliamentary and judicial oversight. Secondly, they argued that the notice that had been issued did not specify the period within which the curfew would last. It was declaring an indefinite curfew throughout the country without an end time to it. They also argued that the notice did not provide for who would provide a permit to those individuals that were considered to provide essential services, and therefore would need to work or operate during the curfew hours. And then finally, they argued in connection to the third argument that organizations like the Independent Policing Oversight Authority and the Law Society of Kenya, their members will need to be exempted and be declared professionals that provide essential services. In the context of lawyers, that since the police officers had arrested hundreds of people, then these individuals needed legal services, which the Law Society of Kenya would need perhaps even to attend police stations during the curfew hours. The discussion that took place in the court, or the arguments and the pleadings that happened in the court, revolved around these 4 issues, but also on Article 24 of the Kenyan Constitution that provides for the limitations of rights, which, like in many other bills of rights on the continent, provides for a 3-part test in deciding whether there is lawful limitation of the right. And this is the limitation, whether the limitation is established in law, it is legitimate, it pursues a legitimate purpose, and whether it's proportionate to the cost that it seeks to acquire. What did the court decide in this case? Now, something interesting happened just after the cause had been filed. The government came into the public and said that the legal notice that the petitioners had relied upon to file the case was a fake notice. And this is one of the issues that came before the court. And this legal notice had not only been relied by the petitioners, but also other interested parties that joined that case, including the Kenya National Human Rights Commission and the Independent Policing Oversight Authority. So the first issue was to determine whether that notice was really the genuine notice. The court said that it was convinced that the petitioners had relied on the notice that had been published by the government. However, the government, through the government printer, produced and saw an affidavit that that was the wrong notice, and therefore that what it had presented before the court was the right notice. The court agreed with it, but really pointed to the fact that the government was acting very dishonestly, that it just published the new notice upon the filing of the case. What this new notice then did was that it was able then to deal with some of the issues that the petitioners had raised. First, the new notice that the government, or the notice that the government claimed to be original, had a specified time for the curfew order. So that meant that it fulfilled the requirement of the law in that regard. But also it provided that the permits for people, for professionals who provide essential services would be given by the police officers. And then finally, it provided that it solved those 2 specific issues about the essential services and the time period. What the new notice did not solve was whether it was provided for under the proper law, whether it was within the Public Order Act or the Public Health Act. The court on this issue said that although the Public Order Act deals with questions of crime, and the courts had previously ruled on this matter that the Public Order Act is really specific to questions of crime. The court ruled that in such a circumstance like this, there is room to provide for the Public Order Act to deal with other similar issues that may need a curfew, like in this case. But the question then moved to the proportionality and the legitimate purpose that the order sought to seek. The court said that it's not very clear to it as to whether a curfew would be able to ensure that the objective of the curfew order is achieved. And the curfew order was to stop or reduce the transmission of coronavirus. The court said, of course, the transmission of coronavirus and the curfew, the causal relationship and linkages is not very clear, especially because the curfew order was in effect during night hours. However, the court then relied on a different principle, the principle of precautionary principle, saying that since we are not very sure about the risks that the exposure or the risk that would lead to higher transmissions of the disease, then the government needs to take precaution to ensure that as little number of people are exposed to the virus. And on the basis of the precautionary principle, the court then ruled that the order is lawful, legitimate, and pursues a legitimate purpose and is proportionate. Where the court really then faulted the proportionality was in relation to police action, where it ruled that the excessive use that had been used, the excessive use of force that had been deployed by the police was unconstitutional, and the police had exceeded their powers, not only as provided for under the Constitution, but under the National Police Act, from which they draw their primary powers. So that is how the court managed to resolve some of the issues that had been raised. It also then ordered that the police, the Independent Policing Oversight Authority and members of the Law Society of Kenya be exempted from the curfew and be able to be given permits to operate within curfew hours. The government never really complied with designating IPOA and lawyers as essential service providers, but in practice, both institutions have been able to have their members operate during curfew hours without much challenge. I'll quickly move to the second case, Joanna Juang and another versus the chief of Ukwala location and several others. This is a case that turns onto the questions of the right to dignity.
Dr. Japhet, you have 2 minutes.
Okay.
2 minutes.
Yes, and it deals with questions around the burial of an individual who was suspected to have died of COVID-19. The case is a little bit complex because this individual had an accident that gave him chest pains, but in the end, after his death, government officials from the place where he hailed from, in the dark of the night at 2 a.m. in the morning, went to his homestead, dug a shallow pit and threw his body. The family raised this case challenging this action on the basis of the fact that it violated not only the right to dignity of the deceased person, but also the right of the family to religion and culture, and in view of the fact that they did not conduct the necessary cultural and religious practices that needed to be conducted before his burial. The court ruled that the act of that burial had not only violated the Public Health Act, but also the guidelines that the Ministry of Health had issued and the World Health Organization had issued, and therefore the burial did not take place in accordance to those guidelines. It violated the right to culture, religion, but also to dignity. And in this respect, the court went around the world to find jurisprudence on the question of the right to a decent burial as an aspect or a facet of the right to life. What I find surprising is that it failed, for instance, to mention the general comment number 3 on the right to life of the African Commission on Human and People's Rights, which makes specific reference about a decent burial as part of the right to life. But the order that the family had sought for the exhumation of the body, testing, and then reburial was not granted. The court ruled that there was a public interest, and again relying on the precautionary principle, that would have to take precaution to ensure that if the individual had died of COVID-19, then the risk of exposure to individuals who would exhume the body, do the test, and do the reburial will be higher. And since we do not know clearly what will be the risk and the consequences of such an endeavor, the court decided that the body should not be exhumed. Instead, a proper burial, a proper graveyard should be made on top of the shallow grave that the government had dug and thrown his body inside. I stop there and hope for more discussion during the question and answers time. Thank you, Emma.
Thank you so much, Dr. Biegon. What a thought-provoking discussion. Thank you so much. Like I said, we'll follow up with questions after everyone has presented. We were supposed to have a presentation from Ms. Ampofo-Anti. I don't know whether she's still online. Ampofo, are you there? I think we lost her. But as and when
I'm still here.
Oh.
I've just been silently in the background.
Okay, awesome. So I think you can proceed with your presentation between 10 and 12 minutes, and then we'll dive right into the questions.
Okay, great. Thank you. Thank you. So I, like my colleagues, are going to try really hard to abide by the chair's 12-minute rule. So in South Africa, a state of national disaster was declared under a piece of legislation called the Disaster Management Act. And that was done in, I think, about the 3rd week of March or so, and lockdown came into effect from the 27th of March. And government basically adopted the approach that it's going to be different levels of lockdown with basically different levels of severity. So level 5 was when no one could leave their homes unless they were going to, do an essential service or obtain an essential service. And the list of essential services was very limited. It was things like your groceries and so forth. In level 4, they started allowing certain types of businesses like manufacturing and so on to open. And then now we are in level 3, and it's anybody's guess as to when we will get to level 2 and level 1. But that's basically where we are. We've been in lockdown for over 100 days. During the lockdown, there have been numerous legal challenges that have been launched with varying degrees of success about different aspects of the lockdown. For example, there was an early challenge to the ban on religious gatherings, which failed. There was a challenge on the enforced closure of the beauty industry, hair salons and so forth, which also failed. There's a challenge on the issue of self-isolation and so on. But in summary, the Minister of Cooperative Governance and Traditional Affairs, Nkosazana Dlamini Zuma, she actually had said to the National Council of Provinces on the 24th of June that there are in excess of 90 legal challenges that the government is facing in different courts over this issue. So obviously there's a huge amount of litigation going on in South Africa at the moment. And of course, the reason for that is that, or one of the reasons for that is that South Africa has a very strong tradition of active civil society and of challenges to state action. And over the past, I would say, 15 to 10 years, we've seen the rise of what I would call lawfare, where you see that whenever government does something that people are not happy with, especially when we're talking about also people who sometimes may be in the opposite political camp or feel that they don't wield political power in South Africa, then we do see multiple challenges to those types of decisions in court. And many of those have been successful because unfortunately the government has made multiple missteps in the past around the way in which it takes decisions. So I think that's why we've seen this sort of flurry of court cases, because people in South Africa do have confidence in the courts, do feel that the courts will hold the government to account where constitutional principles have not been upheld. And so in terms of context of the legal process in South Africa, all high courts would be your first starting point when you want to challenge a decision on the basis of unconstitutional conduct by government or breach of the Bill of Rights, for example. And so you can start at the High Court. If you lose at the High Court, we have a next level called the Supreme Court of Appeal, to which you can apply for appeal, though you usually have to first ask the High Court for what we call leave to appeal. And if the High Court judge who has ruled against you grants you leave to appeal, excuse me, you can go to the Supreme Court. If you fail there, you can go to the Supreme Court and ask them to grant you leave to appeal if the High Court has refused it. And if you fail at the Supreme Court of Appeal as well, you can then, in certain limited types of matters, you can go to the Constitutional Court and you can ask the Constitutional Court to rule on the matter. So that's how it works in terms of levels. Right now, the majority of cases that we've seen have been fought at the level of the High Court. There have been a few attempts for what we call direct access to the Constitutional Court, which is a matter that's a bit complicated in terms of when you can get it, but there have been a few of those as well, where people have circumvented that process and gone directly to the Constitutional Court. But vast majority of the battleground has been High Court decisions. So given the number of cases in South Africa, obviously I can't really give an overview and have not even seen the majority of cases because there are so many, but I'm going to focus on two cases, which are two of the most, I would say maybe controversial that have happened. The first one has potentially far-reaching consequences if it were to be upheld. And that is the case of De Beer versus Minister of Cooperative Governance and Traditional Affairs. So just to put it in context, the reason why the Minister of Cooperative Governance, Dr. Nkosazana Dlamini-Zuma, is the minister who is involved in all of these is because under the Disaster Management Act, she is the minister who has the delegated authority to take decisions under the Act, including the passing of regulations. So even though in South Africa we have something that has been set up by the government called the National Command Council, that is really the one that seems to be taking the decisions, and that has also been the subject of some debate and potential legal challenges. That National Command Council doesn't actually have legal powers under the Disaster Management Act. And so Nkosazana Dlamini-Zuma has to be the one who exercises the actual authority to make regulations, etc., under the Act in order for it to be lawful. So the De Beer case was a case where an NGO called Liberty Fighters Network, which before this case, it was a frankly unknown NGO. But before this, so they launched this case and they basically challenged a number of things. One, they challenged the declaration of the national state of disaster itself. They argued that that was unconstitutional, unlawful, and invalid. Secondly, they challenged the regulations as well that have been made under the Act. Thirdly, they challenged the fact that all gatherings have been declared unlawful, because at that point, you basically couldn't hold a gathering of more than 2 people. A gathering was defined as anything more than 2 people, and that was unlawful. And even now, you actually can't hold a gathering of more than 2 people unless it is for one of the activities that has now been allowed, like convening at a workplace or, and so then there are a number of exceptions that have now been made. The fourth one was that they wanted all businesses, services, and shops to be allowed to operate with the necessary precautions. So some of the issues that they complained about have been somewhat overtaken because the version of the regulations that they challenged at the time was the level 4 regulations. And of course, now we're in level 3. And some of the things they were complaining about are now allowed. For example, there were issues around the period within which you could exercise, which was only 6 to 9 a.m. in the morning. But now you can exercise at whatever time you want. But be that as it may, the decision was taken on the basis of the type of regulations that were in place at the time. And so the court, in short, disagreed with their first challenge, that it was unconstitutional to declare the state of national disaster. They basically argued that it was an overreaction by the government, that there was no reason for it. But the court said, no, actually, the WHO has declared COVID an international pandemic. It's very clear that there's a basis for the declaration of the state of national disaster itself. So the court rejected that first part of the argument. And the meat of the judgment was really around the second challenge, which is that the regulations that have then been made because of the declaration of the state of national disaster are now themselves also unconstitutional. Now, the legal basis for the challenge was the principle of legality. So in our South African constitutional law, the principle of legality is basically the principle.
Ampofo, you have 3 minutes.
I only have 3 minutes left. Wow.
Yes.
Okay, let me see.
I could give you another, but let's say 4.
Unfortunately, I'm only touching on the first judgment, but let's see.
Okay,
So in essence, the principle of legality is that a decision that is made by government must be rationally related to the purpose for which the power was given. Otherwise, it is an arbitrary decision. And so to quote from one of the Constitutional Court judgments, it follows that in order to pass constitutional scrutiny, the exercise of public power by the executive and other functionaries must at least comply with this requirement. If it does not, it falls short of the standards demanded by our Constitution for such action. And then in terms of how does the court approach rationality, the court said that courts are obliged to examine the means selected to determine whether they are rationally related to the objective sought to be achieved. And what must be stressed is that the purpose of the inquiry is not to look at whether there are other means that could have been used, but whether the means that were selected by the government are rationally related to the objective sought to be achieved. And if objectively speaking, there is no rational link between the reasons and the decision, then it falls short of the standards. So the court then looked at the regulations that had been passed and pointed out that several of the regulations were actually irrational according to the court, because the court said that, for example, if a person is ill with COVID-19, they are not allowed any visitors. No one can, be in proximity to a COVID-19 patient unless you are a caregiver, like in a healthcare facility, for example. So people have to be self-isolated or quarantined when they're diagnosed. But if the person dies, then there could be a funeral of up to 50 people attending. So the court said, well, it is irrational to say that if someone is sick to the point where they are dying, their family can't be with them. But even with proper sort of restrictions and boundaries in place, but if they die, then 50 people can gather to bury them. The court, pointed out a number of other issues which it believed was irrational. And as a result, the court declared that the entire regulations were irrational and also unconstitutional because they breached the Bill of Rights. Now, the challenge, of course, with this decision, and it's been widely criticized, that even though, yes, aspects of the regulations are irrational, but the way the court approached it was wrong, because the court couldn't just cherry pick examples that are of irrationality and then declare the entire regulations unconstitutional. The court actually had to look at each and every single regulation on its own and make an assessment of rationality, which it did not do. The problem then means that there's a good chance that an appeal could succeed in terms of the type of reasoning and approach that the court used. But be that as it may, one of the very problematic issues that came out of this judgment was that the approach of the government, because the government actually, according to the court, failed to really try to justify the reasons. Instead, the government was on record as stating that the ends basically justifies the means. And effectively, it looked like the approach of government is that because we're trying to save people's lives, in fact, they actually state that the issue here is that we're trying to save people's lives. And if it means that there's going to be economic hardship, then so be it, because that's more important. And this, of course, is problematic because government actually needs to look at the decisions they are making, try to take decisions which are rationally connected to the purpose, and also to make sure that there is as little limitation on constitutional rights as possible to achieve the objective that they have in mind. But they didn't do that. Instead, they basically seem to have the approach that because of COVID-19 and because I need to control the situation, I can basically do what I want, and the justification is COVID-19, which of course is completely wrong. But it remains to be seen what's going to happen with this judgment. And then if I can just steal one more minute, the other really interesting case, because it's been one of the most controversial issues and very unusual, because I think South Africa is one of the only countries in the world that has done this, is that the sale of tobacco products was banned in South Africa from the beginning of the lockdown until now. Most of us that live in South Africa know that it's still possible to see people smoking cigarettes even today, 3 months later. So obviously there's a huge illegal cigarette boom. But that was challenged by the Fair Trade International Tobacco Association. And unfortunately, that case has also failed because the court has said that there is a rational link between the decision to ban the sale of cigarettes and the objective that the government is trying to pursue, which is that the government could show that there is some evidence, albeit not yet conclusive and somewhat contested, but there is some evidence that COVID-19, people who smoke tend to get sicker from COVID-19 and that they have a higher instance of contracting the disease. And so the court said, well, look, even though that evidence is contested, rationality review does not allow me as the court to look at whether the decision is correct. The issue is whether the decision is rational. So even though there's contested evidence on both sides, as long as the government has got some evidence for the decision it's made, I'm going to rule that it's rational. So in essence, that has also been allowed to continue, and that's much to the consternation of many in South Africa. But of course, that's also being appealed.
Thank you so much, Ampofo, for that very interesting discussion. And to all the panelists, we really appreciate the insights that you all have offered. And I'm sure by now, people have really been raising questions, which we did not bring to your attention. But I think one thing that stands out is, of course, there's been contestation, but there's differences in approaches in terms of how the courts have dealt with the issue. And since Ampofo has just spoken and Biegon just spoke not so long ago, one thing I have noticed in terms of the approaches of courts, South Africa is applying the rationality test. And Ampofo, if you had Dr. Biegon speaking, Kenya seems to be applying the precautionary test. And the precautionary test is one that you're lambasting because it sort of justifies the regulation simply because there's COVID-19. It doesn't go into, the interrogation of the issue. Does this step taken by the government or, by the organ of state actually fulfill the purpose for which it's actually being, legislated or anything to that effect? I want to hear from you and Dr. Biegon in terms of these two approaches. But one thing you also have raised in terms of the issue of rationality is at the end of the day, we are not sure. You're trying to say that at the end of the day, when the FITA case came before the court actually relied on the rationality test. But can we say that rationality test was properly applied in light of the fact that the evidence surrounding the issue of cigarette smoking and COVID-19 remains contentious? So I would like to hear from both Ampofo and Dr. Biegon on the two approaches that the courts are actually applying in terms of these regulations, and then we'll have more questions from both the listeners and for all the other panelists.
Well, look, thanks for that question. I think that's a really important one. And I'm not sure exactly how the precautionary test in Kenya works, but certainly it sounds like it's different from the rationality test in South Africa, where the courts have been very, very clear about the fact that rationality means that the principle of legality, which then results in the application of the rationality test, means that you cannot simply say that this is my reason and therefore I do whatever I want. You have to say, this is my reason, and therefore this is how the decision that I am taking will link to my reasons and fulfill my purpose. If you can't show that, then it doesn't matter what reason you are giving. So even though COVID-19 and the prevention thereof is absolutely important, which is why, by the way, the High Court in the De Beer case said, I will not declare as unconstitutional the declaration of the state of disaster, because we can see how important this issue of COVID-19 is, and the fact that the government must be put in a place to be able to take decisions. But then the court goes on to say, now having accepted that, it does not mean that the government is in a position to take whatever decision they deem necessary. They must rather show us the rationality. And so I think that that's really, really key. Your second point about how do we know it was really rational, for me, that's really the crux of the debate and what makes, I think, the fair trade case so controversial. Because, for example, what the court said is that on the issue of the ban on smoking and the fact that people are still smoking because of the illicit cigarette trade, the court said, even if the ban has not resulted in every smoker in the country stopping the habit, this does not render the ban irrational. Given the test for rationality, it is not whether the means chosen were the best, but rather whether the means chosen could rationally achieve the objective. Now, I find that reasoning very questionable, because if you live in South Africa and have been following the news at all, and I mean, I work in media spaces a lot. I've seen a lot of exposés done by the media, which shows just how easy it is to obtain illegal cigarettes. Illegal cigarettes are being sold everywhere. I myself have been offered illegal cigarettes, despite the fact that I'm not even a smoker. 30 seconds. So the question then becomes, can you really say it is rational for the government to insist on the ban in the face of the clear evidence that it does not work? And instead, you are creating organized crime in the form of illegal cigarette sales. So how, I really didn't understand the court's choice to say that it is rational, even though it actually doesn't work.
Thank you so much. And that's exactly the issue, because this South Africa seems to be, the South African court seems to be applying the rationality test, which ideally would make sense if properly implemented. However, when you look at the Fitter case, it seems to defeat the purpose. So we want to hear from Dr. Biegon, because Kenya seems to be applying the precautionary test, or what you call the precautionary principle. Don't you think that principle, in a way, is a gateway to abuse, creates, a loophole via which the rights can be abused? Because you only say, because there's COVID-19, we will do it. We just want to protect ourselves. We are not sure what will happen. We're not sure whether it works. We're just going to do it because we want to exercise precautionary measures. What's your view on that? Because both of the cases we discussed apply the principle.
Yes, Emma, I think I would agree with you. It would seem that at least in these two cases, the high courts have used the precautionary test or principle to avoid rigor in their discussions on either the rationality of the measures and the curfew that the government has taken, or the proportionality of these measures. So you will see, for instance, in the LSK petition, the judge himself wonders loudly whether these orders really would achieve the purpose for which they have been issued. So he wonders and says, would this curfew reduce the extent of transmissions in the country? But then he quickly moves into the next paragraphs where he says, because we do not know the uncertainty of the potential risk that is involved, then we have to rely on the precautionary test. And the precautionary test was first laid in the context of public health in Kenya in 2018, where the High Court said that in instances where there is uncertainty as to the extent or the risk, potential risks that is involved, then it's better to take precaution. And you will see in the Ajuang case, the judge several times references it's better to be careful than to be sorry. So it's really a principle that they are using to avoid the South Africa's rationality test, or engaging in more discussion and analysis on the proportionality of the actions that the government has taken.
Okay, thank you so much for that engagement. There's a question from someone and it goes directly to Dr. Chilemba. I'm going to read it out loud. The person is wondering, if I understand Dr. Chilemba properly, does it mean that the court would have decided differently if a legislation consistent with the derogation clause empowering lockdown had been in place? Dr. Chilemba?
Thank you very much for the question. Thank you very much for the question. Would the courts have decided differently? In other words, would the courts have allowed the lockdown if legislation allowing for that had been passed? I think that's the question. So I think from the way I explained, was if you see a lockdown substantively and significantly affects the enjoyment of rights. So it means in terms of section 58 of the Constitution, it cannot be done by subsidiary legislation. It means Parliament has to meet and then enact legislation. So pursuant to that, then that law would meet the requirements of section 58 of the Constitution. Now, the issue will not stop there. Since then, there is a law which allows the government to enforce a lockdown. The question will now come whether that legislation qualifies as a lawful limitation of human rights. Because in terms of section 44 of the Constitution, human rights can be limited if there is a law, if it's prescribed by law. So I think that will be, will have been satisfied. But again, it must be reasonable. So the government should show the court that the lockdown which is backed by law is now reasonable. And again, it is necessary. And again, it is in line with international human rights standards. And again, whatever rights are affected by the lockdown do not negate the essential content of the right. So for example, if a person is completely stopped from going out to make money, can you say you have limited or you have taken away completely the right to earn a living? So it means even if the Parliament had passed the legislation that allows a lockdown, the issue now before the court would have been, okay, now we have the law, but is that law in line with the principle of, it should qualify as limitation of rights? So I think we can say yes, if the court is convinced that such law meets the limitation test under the Constitution, then it would have been allowed. But if it was discovered, like in this case, the government would need to show that it has put in place measures to caution, for example, social security measures, so that it should provide for all those people that are negatively affected by the lockdown. If that was done, then yes, it would have been allowed. But again, maybe we should not be quick to say yes, because if you see in the anti-lockdown case, the court was still laboring under whether a lockdown can be enforced without declaring a state of emergency. Okay. Of course, the ex parte Stephen Ponda case, the High Court said, if the law, if whatever measures are taken are backed by law and that law qualifies as a lawful limitation of right, then it's okay. But you see, in the ex parte Stephen Ponda case, it was only one right that was affected, and that was the right to education. In this case, lockdown will affect so many other rights. Then can you say we should just look at limitation? But if you look at the derogation clause, it says...
Thank you, Dr. Chilemba. We're going to tell you to summarize.
Just to conclude, because this is so important. Yeah, the Constitution says you can only declare a state of emergency if there is war or widespread natural disasters. And the court in the lockdown case, I mean in the foreign Chinese nationals case and the ex parte Stephen Ponda case, the two courts agreed that COVID-19 is not a natural disaster. Meaning the issue of derogation doesn't come. So to answer the question is, if there is a law that backs the lockdown and it satisfies all the limitation tests, probably the court will allow that lockdown. But the issue will now have to be, can it be done without declaring a state of emergency? I think I can stop there for now.
All right, thank you so much for your discussion. You know, it's quite interesting because different countries, different petitioners are challenging different laws. And the question becomes, what is law in this regard? Because when we hear from you, Dr. Chilemba, it appears that subsidiary legislation is not law in as far as, you know, regulations that are governing lockdown, you know, are concerned. Whereas in South Africa, we have the Disaster Management Act, which in terms of Section 27 allows the minister to make regulations, and those are rightly defined as law. So the question becomes, what is law and what exactly have these courts been challenging? Because in your view, you're like, if the argument you make and you justify is that if the regulations that are governing lockdown are being put in place by relying on subsidiary legislation, then they are not recognized. And then we have South Africa and Kenya that is relying on regulations and they're rightly defined as law. And to all the panelists today, Mr. Muhindo, there's a question for you, so I'll come back to you, but I would want all the panelists to respond. What is law for purposes of, you know, being challenged before the courts? What exactly is being challenged? Are regulations law in the context of South Africa? Are they law in the context of Malawi? Are they law in the context of Kenya? What is this law that is being challenged and considered to be in violation of the Constitution? Let's start with Ampofo-Anti.
Well, my answer uncharacteristically can be very short. Regulations are law in South Africa for purposes of challenge. In South Africa, any law or even any conduct that is inconsistent with the Constitution can be challenged. So in South Africa, because of the principle of constitutional supremacy, there's no action, decision, or rules or anything of that nature that can be made by members of the executive that could ever be immunized from a legal challenge.
Mm-hmm. Thank you so much, Dr. Chilemba. The case in Malawi seems to be different.
Yes, so maybe I will require 30 seconds more than the previous speaker. Okay, yes. So subsidiary legislation in Malawi is law. So it means regulations issued pursuant to subsidiary to an act of parliament are law. For example, the Disaster Preparedness and Relief Act, that's what the president used to declare a state of disaster and then subsequently close those schools, okay? So it was now the act that this Disaster Prepared and Relief Act, which is the principal legislation, and then the directive which the president issued to close schools. But now when we come to the Public Health Act, now that is the principal legislation. And the coronavirus regulations were now the what? The subsidiary legislation. So again, this is law. But as I said, in terms of section 58, if subsidiary legislation substantively affects the enjoyment of rights, then parliament has to be involved. I think this has to do with the concept of constitutionalism and rule of law. Because in Malawi, we subscribe to rule by the law and not rule by power. So in this case, then, it means if human rights are substantively and significantly affected, parliament should be given a chance now to say something about those regulations. So in this case, what happened was because the lockdown was made pursuant to subsidiary legislation, yet it substantively affects so many human rights, and yet parliament was not involved. That's the problem. But any other subsidiary legislation, regulations, they are law. As long as they just affect rights, not substantively, then there is no need to involve parliament. I think I've addressed your question.
Thank you. Thank you. Mr. Muhindo, would like to hear from you. What is the position in the Central African Republic? That's the issue of consultation, because we need to bear in mind that some of these regulations were basically taken, you know, the time was too short for them to consult. You know, can we say that, you know, in the Central African Republic, all those processes were going through? I'm not sure those processes were considered in South Africa, but from the Central African Republic perspective, were those procedures actually followed? Or is it even a requirement in terms of the Central African Republic law?
So I will combine the two because there is also a similar question. And I talked about the Central African Republic and the Democratic Republic of Congo. So, which is interesting because in terms of constitutional review, they have similar provisions. So what you can challenge before the Constitutional Court is first a law, which is a law of general application, which is in large sense, a law includes act of parliament. They also include act by the presidential decree, which are adopted in the area of the law, because in French constitutional law, you have what we call matters that can only be regulated by legislation, and matters that can be regulated by regulations. So, and Parliament is empowered to adopt legislation, but at some times they can entitle the president with the power to adopt legislation as well. So if the president is empowered to adopt legislations, that will also be called as a law. And if the president, for the matter of constitutional review, adopt, for example, measures on emergency measures, for example, the restriction of freedom of movement and the restriction of the right to freedom of assembly, that is for this purpose considered as a law. And citizens, that's now the question, because when you determine whether this is a law or a regulation or an act which has the force of law, then you will determine whether the Constitutional Court has subject matter to decide over those petitions. And now I will respond even to one of the questions which was posed to me. Are individuals allowed to approach the Constitutional Court in Central African Republic and in Democratic Republic of Congo? Yes, they do. They are allowed to approach the Constitutional Court against the constitutionality of laws, of regulations, and of acts which have the force of law. Acts which have the force of law are those acts which are taken by administrative and political officials. For example, a mayor of a city can ban demonstration, and that for this purpose can be called as a law. So in terms of challenge now, we don't only have the Constitutional Court, you also have administrative court. So you can either decide to approach the Constitutional Court to review the constitutionality of the act, or approach the administrative court to review whether the administrative authority or the political authority who adopts the act had exceeded its power, the abuse of discretion. So you can use the both situations. So two questions. The first one is why people do not go then to challenge. If they're allowed to do so, why they don't do that? Because I was checking yesterday in South Africa, we had more than 21 petitions against lockdown measures, more than 21. And that was a statistic, those were statistics provided end of May. Probably there are some more, but in countries like Congo, Central African Republic, or Togo, you have none. In Kenya, you have some cases. In Uganda, we saw some petitions. In Malawi, you saw some petitions. What is inherent to these countries, of course, with the French-speaking legal tradition, it's more about the legal culture, the constitutional culture. People are not really used to challenge in court behavior of authorities. And this can be even back to the constitutional tradition itself, which tries to empower and prioritize more a cult of personality of the authority, public officials, and the president. So there is difficulties for someone to just stand up. Of course, it's not prohibited, it's not impossible, but it's not in the popular culture that someone can stand and say, I'm challenging the lockdown regulations. So when it comes now to consultation, it's the same thing when you have a political authority, for example, the president, who is empowered in the Constitution of Congo, for example, Article 85 of the Constitution, which empowers the president to adopt emergency declaration. They feel they
1 minute, please.
Yeah. They feel they do not need, apart from the legal obligation, which means the Constitution obliges them to consult the Prime Minister, the President of the Senate, and the National Assembly. And it is not even clear whether the Prime Minister, the President of the National Assembly, and the President of the Senate have to approve it, or they just need to be consulted, because there is two different consultations. It's whether you consult them and they approve, or you just prove that you consulted with them. So when you have that difficulties to consult individual, it then becomes a more of a cultural behavior that you don't consult individual because you are empowered. You don't see the individual who will be affected by that decision. And this is what was recalled by the Constitutional Court of Central African Republic, saying that the constitution that we have from 2016 is the result of consensus, is the result of negotiation, peace agreement. So if you start unilaterally adopting measures that are going to affect the consensus we've built in 2016, this will be derailing from what we've achieved in 2016. You want to amend the constitution beyond what it provides, talk to the people who participated, and this will enhance even the legitimacy of constitutional amendments themselves. So you see here, the issue of consensus even goes beyond the constitutionality. It goes to the issue of legitimacy of measures.
Yeah, thank you. Thank you so much for that very comprehensive clarity. There's a question that goes to any of you could actually answer. And a person would love to know, what's your take if you are to weigh the need to observe constitutionality versus the doctrine of necessity to save lives? I think it's an issue of balancing. The question is basically, the person needs an answer to how rights, should be balanced, where, the government is desirous to save lives and, protect the health of citizens, and then, the protection of lives. I think anyone could bounce on this one. What's your take on perhaps how should the courts actually approach that? I would have loved us to draw on some of the cases and how the courts have actually dealt with that. I know the courts in South Africa have, elaborated on that issue, and the courts in Kenya, and I think Malawi as well. What would be your take?
Okay, Emma, I don't know if I can go first.
Yes, you may.
Okay, because I think the issue of doctrine of necessity can come in if we're looking at the situation in Malawi, whereby the government has tried to take those measures, like enact a lockdown, and then people have gone to court, and the court have stopped the lockdown. So as you can see, we can all appreciate that COVID-19 here is a serious threat. Should the government be stopped from really taking measures to protect Malawians? So perhaps that's where the doctrine of necessity will come in, like in the case of Malawi. Because this doctrine was touched upon by the court in a certain case, which is called the press trust case, whereby members of parliament had walked out so that to frustrate government from enacting a law. And then the government just proceeded to enact a law without the quorum being satisfied. So the court said, this law was so important, and you walked out deliberately to frustrate the government's effort to enact such legislation. Perhaps then there, the doctrine of necessity can come in. So I think looking at this particular case, if this is now my view, if government had followed whatever the law is requiring, like the constitution, taken the lockdown legislation before parliament to be passed, consulted properly, and then Malawians were okay, I think this lockdown is important. And then it's taken before parliament, and then parliament abuses its powers and acts mala fides, deliberately to frustrate government. Then government can go before the court and say, we did everything that the law requires, but members of parliament, out of their own self-interest, have frustrated our efforts. Then the courts can now invoke the doctrine of necessity, because the government has done what it's supposed to do, but someone out there is abusing their own power. Unfortunately, that's not what happened in this case. The government did not involve parliament. So already here, the doctrine of necessity cannot even arise, because the government has not done its part. It's only where the government has done things right, and then someone out there is frustrating the efforts, that's when the courts can invoke the doctrine of necessity. But in this case, the government is shooting itself in the foot by not calling. Both someone would say, but looking at the time, should we really call parliament to meet and enact? The government did not even try to convene parliament to deal with these matters. So I think, yes, the doctrine of necessity can come in, but only where the government is acting in good faith and someone out there is frustrating this. But as in the case of Malawi, this situation has not arisen.
A follow-up question regarding Malawi. One of the cases that you shared with us suggests that the government has not always been very cooperative when it came to proceedings, against it. In one of the cases, particularly the one you sent is the Attorney General did not show up, and instead he actually preferred to actually make submissions via the media as opposed to appearing in court. how has the environment and the relationship between the judiciary and the executive affected how the judiciary adjudicates over cases surrounding the issue of COVID-19?
Okay, if you remember my presentation in the beginning, I set the context in the Malawian case that we were approaching fresh elections. Then already there were some suspicions that, come on, the government is not being honest. So it was not involving anyone. It was not talking to the civil society organizations. It was not even involving parliament. And the task force that was entrusted with looking into the issues of COVID-19 was predominantly cabinet, and it was headed by the cabinet minister. And then there were issues of lack of transparency in the management of funds. So already the public was suspicious. Perhaps whatever the government is doing is trying to run away from elections, or they're trying to abuse funds. So already there was suspicion. The scene was set for doubt and suspicion. So that's why when matters went before the courts, if the government was not doing things right, then the court would throw away, would stop the government in whatever it was doing. Now, what happened that time was the government started lambasting the judges in the media. For example, there was a statement issued by the government spokesperson. Here we're talking of the previous government, since we have changed government since 23rd June, which criticized the decision which allowed the Chinese nationals to remain in Malawi. And again, when the court had issued an injunction stopping the lockdown for 7 days, the government again talked so much. So there was a feeling that there is an attack on the independence of the judiciary by the government. So I think the scene there was set. And if you captured me correctly, I was saying the government was not doing things the right way. No wonder it was just losing cases before the court. And even this lockdown, the way it proceeded, without involving parliament, without consultation, again, that's why the court issued an injunction. So when the Attorney General applied to vacate the injunction, my view is that the government already saw that they would not win that case. That's why they tried to withdraw from the case and not participate. Now, what puzzled the public was after the government had withdrawn from the case, the Attorney General went into the media and started blaming the judiciary. I think there was a statement that was made that if COVID-19 spreads in Malawi.
Dr. Shilemba, you have 1 minute.
Yes, yes. So the Attorney General made the statement that if COVID-19 spreads in Malawi, we all know who is to blame. We are sure the court will do the right thing. So as you can see, indirectly, the Attorney General was trying to say, we as government are trying to do the right thing, but you, the court, you're trying to frustrate us. So this would amount to an attack on the independence of the judiciary. You have walked out of proceedings and then you're going to the media to do that. So this decision, the lockdown case, the court actually faulted the Attorney General that you are not supposed to run away from your responsibilities. You should come before a court and give us the side of government. So I think we can say, yes, so in conclusion, we can say that there was a war, not between the judiciary and the government, but I think it was one side. It was the government that was attacking the judiciary. And I think either it was due to frustration and all that, but it all boils down to the environment in which Malawi found itself in before the elections. Thank you.
Thank you. Thank you so much for that comprehensive answer. Ms. Ampofo-Anti, you indicated at the beginning that there is over 90 legal challenges currently taking place in the various courts in South Africa. Yeah. Do you think thus far, and quite a number have also been dismissed? We know cases by Musi Maimani, the Suzman Foundation, and quite a number that have been dismissed. We also have cases that are basically arguing, advancing arguments to the effect that the lockdown is causing, people to suffer and violating rights. People cannot afford food, people cannot, go to work and stuff like that. The question becomes, are the petitioners in these petitions actually invoking the right strategy, in your opinion, based on the two cases that have already, you have dealt with, the Fita case, for instance, and the other case that you discussed? Do you think the petitioners are invoking the right strategies that would lead to successful litigation in their matters?
Well, look, I definitely think that in the case of the the beer case, which was the case where the court ruled the entire thing, lockdown regulations, to be unconstitutional, that the petitioners did raise, the correct issue specifically relating to rationality of the regulations. But the problem is that, how do I phrase this? I think there's some technicalities in this, in the way that they approach the issue, and in the way in which the court also then approached their issues, which actually turned out to be wrong. Because I think their argument in substance was correct, which is lack of rationality. But then from a technical point of view, you need to apply rationality to each and every single element. And the judge also needed to have done that, and he didn't do that. And I think that then opens up the fact that this is going to be successfully appealed. As to what the outcome of the appeal may be, the court may then decide to do that step-by-step analysis on its own, or it may say, well, I'm not going to do that because the case was ill-founded. You can't challenge the constitutionality of an entire set of regulations without telling me why each and every single one of them is right. So I think that they are substantively correct, but technically wrong in the way in which they go about it. I think that the FITA case, I do find the outcome of the fair trade case to be disappointing, because I don't think that they chose the wrong strategy in terms of arguing rationality and the challenge that they went for in terms of the core part of their challenge. Of course, there are other smaller parts to their challenge which one can debate, but the core issue of rationality, they were not wrong. The problem is that the court just said that they didn't agree with them. I do, however, wonder why in both of these cases, there doesn't seem to have been, at least based on the judgments, because I haven't seen, the underlying court papers, but based on the judgments, there doesn't seem to have been as much emphasis on the angle of constitutional rights, especially in the case challenging the general aspect of the regulation, because I think that if there had been more of a focus on what are the rights of people in South Africa that are actually being limited, and then let's do the analysis under Section 36 of the South African Constitution on whether or not this limitation of rights is reasonable and justifiable in a democratic state. And I haven't really seen that, certainly not in these two judgments, and I'm wondering why. And I'll give an example of where I think that may have been a good thing to do. For example, in the fair trade case. In the fair trade case, they made the argument that tobacco should have been an essential product. And one of the things that they threw in there was that, well, it should be an essential product because many people are addicted. And the court said the fact that you're addicted to something doesn't mean it must be given to you as an essential product. But the angle that I wonder about, whether they thought about it and why, maybe they did, but they decided not to go with it, is that what about the rights of the people who use tobacco products not to be subjected to inhuman, cruel, and degrading treatment, for example? Because if you look at, and I saw this in one of the exposés, the consequences of uncontrolled withdrawal from nicotine addiction and the impact on people's bodies when they have to go through that. I mean, I saw people talking about how they've started hallucinating, they're having tremors, they are thinking of gathering the grass from outside and just smoking that. So yes, you may think that, of course, using cigarettes is not a good thing for your health. But the point is that prior to the lockdown, cigarettes were not illegal in South Africa, which means that people were allowed to use them. And having done so, they've developed a physical dependency. And coming off that physical dependency is hugely impactful on your physical body as well. So what about your constitutional rights around that, and the right for the government not to subject you to those physical symptoms and the withdrawal associated with that without giving a proper justification for the limitation of those rights? So that's number one. The second thing that I wonder about why it wasn't argued.
Ms. Ampofo, you have 1 minute.
1 minute. The second thing that I wonder why it wasn't argued in the fair trade case around rationality is, sure, there's evidence, whether it is under debate or not, but there's some evidence that people who smoke are at a higher risk of contracting COVID, and that when they do contract it, they become sicker and that they need ventilators. But is there any evidence that a person who has been smoking over a continuous period of time when removed from those cigarettes, will not suffer those consequences? Because for me, that was the biggest rationality question. And I was wondering whether it was addressed in the papers, because it's not in the judgment, that sure, you have evidence that people who are smoking have these consequences, but where is your evidence that if I've been smoking for 10 years or 20 years and you make me stop on the 27th of March, 2020, by the 27th of April, a month later, the 27th of May, 2 months later, or even now, all of a sudden my lungs will be cured and I will not suffer those consequences? Because to me, if that is not there, then where is the rationality? So, you know, those are some of the questions that I asked myself about, well, why didn't they argue that?
It's quite interesting. And, you know, from your discussion, what I gather is, you know, the gap is not just on the side of the litigants, it's also on the side of the judiciary. They're not engaging with principles. Sometimes they're just throwing principles and not critically engaging them and applying them rationally to the issues for them. One last question before we conclude goes to Mr. Muhindo. Mr. Muhindo, you alluded to the fact that although there are quite a number of critical issues, Mr. Muhindo, are you there?
Yes.
Yes. Although there were a number of critical issues that came up in this case that you discussed with it, the court did not engage critically with a number of issues, including, you know, the human rights issue, including being specific, for instance, about, you know, issues of elections and so on and so forth. And we have already learned from the situation in Malawi that, you know, the courts are always being lambasted by the judiciary. With regard to the situation in the Central African Republic, I would love to know, do you think that the decision or the approach of the court to avoid these critical issues is deliberate, to avoid being in bad books with you know, with the executive or the other arms of government? What's your opinion in terms of how the court approached this issue? And as you answer that question, what has been the history of the judiciary in the Central African Republic in terms of how they have dealt with cases, especially where the government is a party?
Yeah, thank you so much. Those are interesting questions. I will start by reflecting on the constitutional reasoning itself. And I pointed out these issues to be similar, both in the Democratic Republic of Congo petition and in the Central African Republic. And this, you can see it, for example, when the members of parliament in the Central African Republic argued that COVID-19 can be seen as a force majeure circumstances. For a reminder, force majeure is generally considered as a liberatory condition under general law, be that in contracts, in constitutional law. When you have obligations and you invoke the force majeure, you are not obliged to fulfill or to accomplish your obligation. So this was one of the arguments members of parliament on the ruling coalition in Central African Republic raised, saying that based on the doctrine of force majeure, we cannot organize elections in December 2020 and in March 2021. But then the court did not address that issue, which means the court did not tell us whether the force majeure can be used to extend elections, for example, or to extend the presidential term. When you read the case, it doesn't either say that the force majeure cannot stop to organize elections. So the court focused the reasoning only on the consensus. I think it implied that, yes, elections can be extended, presidential term can be extended, but this should result not from parliamentary constitutional amendment, but from the consensus. So you have to consult everyone. And I find that very problematic, especially in terms of legal security and legal stability. You have to explain to individual what is there. You know, you have to devise a legal framework. What is the force majeure? We know that force majeure must be external to the actor. So the person who invokes force majeure must not be the one who caused it. We know that the force majeure should be an event that is unexpected, and COVID-19 actually is unexpected. We know that the force majeure is something that is unsurmountable. You have to show that. But then, can it be used to extend elections? The court did not do this. And in the DRC, the same thing. When you have, for example, a minister of interior taking measures to restrict the freedom of movement before the declaration of of the state of emergency, which means there was no legal ground to restrict the right of people, but the Constitutional Court does not go there. So putting these two issues in perspective, is there some underlying issues with the judiciary itself? So the problem is more about the legal tradition in the legal court, and the legal tradition is more a tradition in the French civil law legal tradition is more deductive instead of inductive, where you see in common law arguments are drawn from experience, but in the civil law legal tradition, the reasoning is more deductive. So you invoke principle, you invoke the law, you apply the facts, and you don't go deeply into the reasoning. Some scholars have argued, for example, that the problem here, they don't want to lay general rules that will be applied to all the cases by conceptualizing concepts such as force majeure. So instead, they will say this can be assumed to be a force majeure without defining what force majeure is. This gives them the latitude for future cases to use the same argument. So is there a history of manipulation of the judiciary by the executive? Yes, of course, there is. If you look at the different generations of constitution making in Africa, starting with the 1960s, where the judiciary in most French-speaking countries were used as an instrument to oppress the opposition and to silence dissent in the society, there is that culture of judicial deference toward the executive, which has continued, even if in 2006, for example, in DRC, there was a new constitutional order, and even in Central African Republic in 2016, there is a new constitutional order. You see that culture, that attitude, not only of judges to respect executive, not only individual to be worried to venerate executive orders, it continues up until now. And this is not only exacerbated by those attitudinal stances, but also the manner in which laws are framed themselves. In the constitutional law, for example, there is no provision on public interest litigation, and these conditions are very strict. So for you to approach the Constitutional Court, you must show that you've been victim. You cannot approach the Constitutional Court on behalf of either the community or another individual. You see provisions such as the amicus curiae do not exist there. So you see it's more strict and it's restricted, and one needs to look at both constitutional framework, but also cultural issues and the attitude towards the judiciary to comprehend the whole issue that these emergency petition will deal with.
Oh, quite interesting, how tradition ultimately impacts on, how, decisions play out in court. Thank you so much for that clarity. On this note, I'm trying to see if there's a question I've left out, but I think some of them were somehow answered along the way. But we have really come to the end of our discussion. But before, we conclude, what happens after that? After all this, quite a number of, rights have been violated. And, you just told us that in countries like, the Central African Republic, you don't have systems, enabling issues like, public interest litigation. Where does the Central African Republic go from here? Where does South Africa go from here? Quite a number of rights, have been violated. In Malawi, where do we go from here? With the coming into force of the new government, have things changed? Will there be greater protection of rights now that, there's a new government in place? What will happen? How about the cases that are pending before court? I'm aware that, the FITA case is due for appeal in the Supreme Court of Appeal. What is the future, of litigation surrounding, COVID-19? In a minute or two, at most 3, just give us your concluding observations. Please stick to the time.
I will go first. Less than 1 minute. I think from this French-speaking perspective in Africa, there is need not only to have enabling legislations. When I say enabling legislation, is standing orders of courts, and the constitution themselves should promote a culture of litigation and allowing, for example, that people can approach the courts on behalf of other individuals. And trying to ensure that formalities are not upheld to the maximum. Because sometimes when you approach the court and you are told that you were supposed to come at 12 and it's already 2, while it's clear that you couldn't do anything. We saw this in some electoral petitions. So these are things that are discouraging individuals from approaching the court. But also in these countries where you have the liberalization of the access to courts, when I look at most French-speaking countries before 1990 could not allow citizens to approach the court. But after 1990, and especially after the 2000, most of them now allow individuals to approach the court. But individuals have kept that in mind that they cannot approach the court. And perhaps because even when the court renders its decision, the decision is not implemented. So there is really relevance to bridge the gap between the demand of justice and the supply of justice. And when you bridge the gap between demand and the supply of justice, at that point, then you can ensure perhaps that people will have trust in the legal system, people will have trust in the legal process, and the judiciary will properly uphold constitutionalism, both in normal situations, but also in emergency situations.
Oh, thank you so much. Ms. Ampofo, what do you have to say with regards to South Africa?
Well, look, I think one of the big problems that's happening in South Africa at the moment is the proliferation of disputes, because we are seeing different decisions being taken by different high courts. Because just to put everyone in context, we've got multiple high courts across South Africa, not just one. And so, and also what happens in South Africa is that the decision of one high court is not binding on another high court. It's only persuasive. And so we've got this proliferation of over 90 cases in multiple fora, in the high court and so forth, whilst others are being appealed. And the core issues in most of them are actually very similar. And in many cases, they're virtually the same, which is it rational? Should the national state of disaster have been declared? Is the lockdown acceptable? All of those things. And so I think that's a real problem, because we're seeing different decisions being made for different reasons. For example, on the one hand, we have a decision about the opening of hair salons being dismissed in one court, and then we have the entire regulations being declared unconstitutional in another court. So what is the status right now? So I'm really hoping that the future of this thing will become clearer when this De Beer case is decided by the Supreme Court of Appeal, because that will now be binding on all high courts. And the De Beer case is going to be really important because it's going to settle the question of whether the regulations as a whole, hopefully, can be viewed as unconstitutional. Hopefully that can be taken off the table by one decision by a higher court. And I also hope that the Fair Trade International Court, the Fair Trade International case will go to the Constitutional Court as well. That one of two of those cases will go to the Constitutional Court. Then we can have the Constitutional Court making a unifying decision about the correct approach to rationality, the correct approach to analysis of where do constitutional rights and the limitation thereof fit into this whole analysis, and whether the lockdown as a whole is unconstitutional or not. If we can have some decisions on those from the Supreme Court and the Constitutional Court, I think it's really going to help us, because it's going to hopefully it will help the government to start taking the right kind of decisions and to back away from some of these cases, because once the SCA and ConCourt has ruled, then they will realize, oh, we're going to lose here, we're going to win here, and then matters will start to hopefully be resolved or dissolved. But ultimately, I think the biggest challenge, of course, is that it is a moving target, because every time, because our government has decided to have this phased approach to lockdown, and each and every single time they move us from one level to another, they change the regulations, and that is making it a moving target. So I think we're going to be seeing more and more and more cases. Hopefully the Supreme Court and ConCourt decisions will narrow those down, but I think the fight is going to continue for a while.
No, thank you so much. Thank you. Dr. Shilemba, there's a new government, the same judiciary that has been around, but cases are still ongoing. What is the future of constitutional litigations around the issue of COVID-19? Where do we go from here?
Okay, the future is there, but I'll answer that question in two ways. First, on the chat, there was a comment which asked me that, can the government say we are doing this because the Constitution does not stop us from doing it. In other words, the principle which says what is not forbidden is allowed. So there was a question on chat which was directed to me. So I'll answer that question by saying that in the ex parte Liao case, which involved the foreign Chinese nationals, the Chinese nationals case, the court said in Malawi, whenever the government is doing something, they should not say we are doing it because the law doesn't say we shouldn't do it. Instead, the government should do it by saying we are doing it because the law tells us to do it. In other words, if the government takes any measure, the question is, oh, government, you have done that. Tell us which law tells you to do it. So I think that has set the scene for Malawi. That's why when the lockdown was put into place, the government could not argue that we have been enforced a lockdown because the law does not stop us from doing it. The question became, which law tells you to do the lockdown? So as you can see, I forgot to say one thing, that the lockdown case, there was also the Human Rights Defenders Coalition that was involved. Now, the new government is in place. The president has said they will not pursue the lockdown issue because I think I think looking at the Malawian context, it cannot work. Yeah, it cannot, because when the lockdown was just announced, there were so many demonstrations throughout Malawi. Everyone was just demonstrating. No one was happy with it. So this new government will not pursue the lockdown, but yet it has to deal with the pandemic. So the future is there. I think the government can just involve parliament, enact laws, and do it. But since whatever the government is doing has to be in line with the law and the Constitution, it means if the government does anything that affects rights, even if it's for the good, there will be litigation. You know why? Human Rights Defenders Coalition, the issue of standing is relaxed in Malawi. As you saw, even third-year students went to court in our university. So it means people can still go to court and say, hey, you haven't done this, then the court will come in to step in. So yes, there is a future to litigation in Malawi. I think that's why the government is taking its time to study. Actually, Malawi is now saying, hey, now you're in power. 1 week has gone. What are you doing about coronavirus? I think learning from the past, the new government is trying to tread cautiously, because I think Malawi is not just like any other country which you can just enact measures and you get away with it. The measure has to be constitutional, has to be in line with the law, and they should not violate rights, because then you'll be asked, whatever you're doing is trampling on rights, stop it. So I think it's not easy for the government to get around this. Thank you.
Thank you so much, Dr. Chilamba. Dr. Biegon, from your discussion, we gathered, and one thing that is critical, we see the decisions of the court in one way or the other trying to strike a balance between public, the health, of the public and the individual rights of the people. We saw that in the Adjoang case and in all the other cases. We see application of, principles such as the precautionary principle, and you question, how the court applied them. Where do we go from here? There's quite a number of human rights violations from what we gather from the decisions of the courts, we read. Do we hope to see more litigation, going forward? Do we hope to see people settling? Do we hope to see appeals to the decisions that have already been arrived at? What is the posture of the judiciary going forward?
So as you may know, there is a very strong culture and practice of public interest litigation, especially in human rights issues in Kenya. There is a very active citizenry that challenges government actions and laws. So the cases that we have seen here is just part of the broader huge culture of public interest litigation. And already there are a number of cases that are pending in court concerning COVID-19, one of which challenges the forced quarantine or isolation of individuals. Under the Public Health Act, anyone who goes into quarantine, the hospital or the facility would have first obtained an order from a magistrate to do that forced quarantine. But under COVID-19 situation, individuals have been quarantined without such an order from a magistrate. There is another case that challenges the imposition of cost for individuals who have been quarantined, isolated, or treated for COVID-19 in government facilities. Under the Public Health Act, such a cost should be borne by the government that is in charge of the government facilities. Although this issue might have been spent already because when the government saw that not so many individuals were willing to come out to do the testing, they then made it free. But long before they made it free, many other individuals had been slapped with high invoices and bills after treatment or after going through isolation. So we are likely to see more litigation on COVID-19, and the issues that really impact on litigation in Kenya are broader issues of governance. So we've seen, for instance, a strong embedment of a culture of non-compliance with court decisions in the recent past, including in the LSK petition that I discussed during my presentation. So in this case, the court ordered for the government to declare legal services and the Independent Policing Oversight Authority as essential service provider. Up to date, that has not happened, although practice has changed, but that order has not been complied with expressly. So the problem really lies in government's compliance with judgments, but also, like in Malawi, we have seen a sustained attack and propaganda against the judiciary in the recent past, tied, of course, to political changes that we anticipate in the next 2 or so years. So that political onslaught against the judiciary also impacts on litigation generally, but also on the rule of law. We've also seen in the past government trying to clamp down on public interest litigation by slapping heavy bills on individuals who file public interest litigation, but things have changed in the recent past, but also in the context of the cases of COVID-19, where the courts have ruled that each party would bear their own cost. So generally, I would say that I see a future in terms of individuals and citizens and NGOs filing cases continuing into the unforeseen future. Thank you, Emma.
Well, thank you so much. Thank you so much to all our panelists. Thank you, Dr. Biegon. Thank you, Dr. Chilemba. Yes, thank you, Mr. Muhindo and Ms. Ampofo-Anti. This is one of the most engaging discussions I've had in quite a while. And, hearing perspectives from across, South Africa, Central Africa, East Africa, it's been quite fruitful. And one thing I think I should have asked, but I think I want to believe is, Ampofo-Anti, you will notice that when the regulations are being rolled out in South Africa, the government was so adamant. If you saw, ministers like the Minister of Police, the way he spoke, it was like he was the new sheriff in town who could not be questioned. And one thing we must all acknowledge is that although some of these cases have not been won or anything to that effect, they have sort of changed the attitude of the government in terms of how they deal, with regulations, in terms of how they, consult people, issues like that. And I believe that has been the position, across Africa. So I believe litigation has been more than winning a case. It's brought about awareness. It's checked the government, in one way or the other. And so, and I think that is what really litigation is about. It's not about winning cases. It's about, sending a message out there. On that note, I just want to thank all the panelists in today's webinar. It was quite an engaging discussion. Thank you for sparing your time to be here. It took longer than we expected, but that's because we started late, and of course there was still a number of technical issues. And of course the issues we were, discussing were quite, critical, that we could not just stop the webinar in the middle of it. But I just want to thank everyone that contributed today, everyone that was on the sidelines, making comments, asking questions. This was quite fruitful and engaging. And I'm sure we'll be more alert about what goes on and all the cases that are going on in our various jurisdictions. I wish you all the best. I wish you a good afternoon, and welcome to all the forthcoming webinars that will be on this platform. Thank you so much. Have a lovely afternoon.
Thank you too. Thank you so much.
Thank you. Thank you. Well.
Thanks, everyone. Bye.
Bye-bye. Bye.